Hello everyone, welcome to PWLIAS. How are you all doing today? Well, let me just take you to an important topic that has come out very recently. In the newspapers, you would have read about it. It is basically the Supreme Court ruling in 6A. Well, you will be thinking about what is a public administration faculty for paper 2 doing with Supreme Court ruling in 6A. Well, this ruling has implication from two chapters. One is the second chapter, the constitutional and theoretic, philosophical and constitutional framework of our government, and obviously the chapter on union government and administration where we talk about Supreme Court ruling. So everything that comes in the paper, newspaper, has an impact on paper 2 of PubAd. Getting the point here? Now I'm going to tell you, while I explain the article, you will get to know that when you choose public administration and optional, how it makes things easier for you as far as Indian polity for prelims is concerned, number one. Number two, how it makes things easier for you when it comes to GS2 of your mains. So this is one such optional where it will easily make things smooth for you when it comes to two of the most important areas of UPSC. Clear? So before we head on further, a quick introduction to my official Telegram channel where you can reach out to me with regard to your preparation doubts, with regard to your polity doubts, with regard to your PubAd doubts. You can send me answers of GS2 from 2013 PYQs only. Please don't send me the DMPs or the questions that you picked up from some other institution's test series. Only the PYQs you need to send, and that too in the PDF format. You can do this for GS2 as well as for PubAd. Clear, people? So this is the idea. Taking it further forward, citizenship. So before we start this, a brief background you need. When we start the whole discussion on the ruling of Supreme Court, we need to know the background. The background is the Assam Accord has been signed on 15th August 1985 amongst Union of India, Government of Assam, All Assam Student of Union, All Assam Gana Sangrama Parishad. All right. Within all these entities, they made the signature. What was this about? Well, I'll tell you again in brief. That is, when India became independent in 1947, you need not draw maps for your optional paper. But when it comes to your GS, yes, you will have to draw. Clear, people? So when India became independent, basically what happened was migrations were happening. All right, from both the sides. Let's assume this as Bangladesh now. It's not so accurate, but just adjust with me here. So basically you had migrations happening from Pakistan to India and India to Pakistan. But this basically got over in a single year. And again, being a flat terrain and everything, it was easier to secure the border on the western front. I'm talking from Gujarat to maybe, let us say, till Punjab. You're able to secure it. But that was not the case in the east. In east, this influx of refugees or of people from East Pakistan kept on coming in. And this especially peaked up during 1971. And when they came in also, they didn't come to one single place. They started moving all the area around. That is West Bengal, Assam, Meghalaya, Tripura, everywhere they started moving around. But the impact was felt very worse in the state of Assam. Why? Because first of all, it was a geographically, if you see, it was a small territory with a very low population. The Bengalis from Bangladesh, when they came there, the people felt disturbed because they felt their culture was getting disturbed. It led to a lot of skirmishes, a lot of problems, revolts, violence, everything. Finally, in 1985, the Assam Accord was signed by the government of India with the various organizations of Assam. And one of the clause in that was to keep the cutoff date. The cutoff date to decide from after which date if people comes here, we are not going to allow it or we are going to deport them. What was that cutoff date? That cutoff date was actually March 25th, 1971. Now, why was this cutoff date chosen? Why not 24? Why not 26? March 25th was chosen for the reason that it was on March 26th, 1971, West Pakistan launched Operation Searchlight, where this Operation Searchlight was launched in East Pakistan. What was the purpose of that operation? Find out all those people who are against West Pakistan or who are supporting Bangladesh independence movement. Find them, kill them. If they are males, kill them. They are women, rape them, murder them. This was the thing. So before March 26th, whoever came, or March 25th, before whoever came before that, on or before that, we consider them to be what? They are immigrants who came from East Pakistan. After March 26th, why we are not considering them as immigrants, but we are treating them as refugees? Because March 26th onwards, this entire area was filled with too much of political disturbances. So whoever came, they came running for their fear. Out of fear they came, fear of their life. Getting the picture? This is the cutoff date now. So now we are going to see how Section 6A has been interpreted by the Supreme Court. What were the arguments of the petitioners? What did Supreme Court rule? Let us see those one by one. Section 6A added through Citizenship Amendment Act of 1985. So Section 6A was added to the Citizenship Act of 1985. That is, Section 6 is there. Then 6A was added. Why? To give effect or strength to the Assam Accord, whereby which the cutoff date was finalized as March 25, 1971. Conferred citizenship to those who migrated from East Pakistan to Assam from January 1, 1966 until 25th March 1971 upon completion of 10 years from the date of detection as a foreigner. Simply means if somebody would have come even on 24th March 1971 and if they have completed 10 years, 1981, they will be considered as a citizen. They will be conferred with citizenship. So now let us see what did the petitioners argue. They basically said why Article 6A is extended only to Assam. Because immigrants came everywhere. They came to West Bengal. They came to Meghalaya. Why only for Assam this exception has been created? First question. Second, the cutoff date is arbitrary. I already told you it was not arbitrary. It was chosen based on the cutoff, the date of launch of Operation Searchlight. So this argument of the petitioner does not carry any merit. Third point, as per Sonowal case, illegal immigration is external aggression. That was a Supreme Court ruling in another case, called as the Sonowal case. But Supreme Court basically made the ruling that illegal immigration tantamounts to external aggression. So they used that same argument. They said that Sonowal case, whoever came illegally, we have categorized it as external aggression. So this also, whichever immigrants came from Bangladesh should be categorized as what? External aggression. Last one, it's a violation of Article 29. Because so many Bengalis had come from Bangladesh, it has affected the indigenous culture of the people of Assam and their culture is under threat. So this should be struck down. The 6A should be struck down. They should not be given citizenship. This is the argument. Now let us look into what Supreme Court said. Parliament has all the rights to decide matters of citizenship. Very, very important. Article 6 and Article 7 gives the complete freedom and the right for the Parliament to decide matters of citizenship. That is, they can even give somebody citizenship. They can even take it away also. It's up to the Parliament. Nobody else can decide on it. This is the first clarity that Supreme Court has given. Very, very important considering the next set of rulings that are going to come, especially with regard to Citizenship Amendment Act, the CAA Act. Going forward, Section 6A of Citizenship Act has kept the cutoff date as March 25, 1971. CJI also stated that the cutoff made of March 25, 1971 is also reasonable because the Pakistani army launched Operation Searchlight to curb the Bangladeshi nationalist movement in East Pakistan on 26 March 1971. So the argument by the petitioners that the cutoff date is arbitrary was struck down by the Supreme Court by telling that there is a logic to it. And the logic is on March 26th, it was actually the date of launch of the Operation Searchlight. So March 25 being the cutoff date is absolutely reasonable. Therefore, migrants before the operation were considered migrants of the Indian partition. So whoever came before that, they are considered as migrants because of the partition. Section 6A was added to give effect to the Assam Accord of 1985. It grants citizenship to persons of Indian origin migrating from erstwhile East Pakistan due to political disturbances in a foreign territory. 6A allows for controlled and regulated form of immigration and does not tantamount to external aggression. So it is controlled. Section 6A, because obviously we kept March 25 as the cutoff date. Whoever came, it is not external aggression. They have not come illegally. They are people who have come back to our country as a result of the partition, and it will not be considered or treated as external aggression. Now, those of you who have read Lakshmikant should be knowing that emergency provisions are there in our constitution, and a national emergency can be declared on grounds of war, external aggression, and armed rebellion. Allowing the Sonowal ruling will put Article 355 in the hands of court and citizens. What does that mean? If court starts deciding what is external aggression, then automatically it becomes that court can decide now whether national emergency should be declared or not. Correct? Emergency is declared, or declaring emergency is actually the prerogative of the executive in consonance with the parliament. So taking away the legislative and executive rights will amount to what actually? Judicial adventurism. It is not judiciary's job to decide what is external aggression and what is not. So judiciary is staying within its limit, which is basically one of the fundamental principles of our constitution. Clear division of powers is there. At the same time, cooperation is also there. That is, even when we know that there is a legislature, you have a legislature, you have an executive, you have a judiciary. All the three, if you actually see, there are certain areas where overlap is there. At the same time, each one of them have separate roles to do. So judiciary clearly made it very clear that no, they are not going to interfere with the work of what? Legislature and executive. So this is one of the founding principles even in the classical theory. Clear division of authority and responsibility. Classical theory that comes under paper 1. Getting the point here? This is the easiest way to study. So under classical theory, paper 1 talks about division of authority, division of responsibility. Supreme Court is abiding by it. Clear? Then Assam, not like other states as it is small and was mostly affected by the migration. Like I told you, unlike the other states, Assam being very small, they were the most affected by the migration. And that is why 6A specifically talks about the migration of the people who came to Assam. Clear? And that is why we are giving or granting them citizenship. Mere presence of different ethnic groups in a state is not sufficient to infringe the right guaranteed by Article 29, Clause 1. What does that mean? Just because people from another state is there in a particular state, how is it that going to affect their culture? Because actually, our constitution guarantees what any minority can actually run an institution of their choice, religious or educational. They can they have every right to protect their culture. It is guaranteed by the constitution. So just saying that presence of another ethnic group will affect the culture of a state, when you say, you must understand, if we allow that, let us say we are allowing it for the sake of argument. Oh, another group is here, my culture will get affected. What will that lead to? Further litigations. Further litigations where people can come to the court and say, oh, in my state, state B people are more, my state's culture is getting diluted. Please ask state B people to leave from here. The founding principle of our constitution, fraternity, brotherhood, that will get destroyed. That is from paper 2, chapter 2. And you also know, preamble is a very important section within the polity for prelims. Justice, liberty, equality, fraternity. Correct? So that fraternity will get affected. If we entertain that thought that presence of another ethnic group will affect my culture. So to promote it, what? We need to have unity in diversity. We need to have diverse cultures to be harbored in every society. We should have the tolerance as well as the sense of acceptance. Only then the founding principles with which our constitution was made will be honored. Clear? Moving on. With that, we come to an end of our discussion. Was it so difficult? Do you understood the concepts already? Why Supreme Court gave that ruling? How Supreme Court limited itself from not trespassing into the domain of the executive or the legislature? How important it is to have division of powers and responsibilities as per the classical theory of paper 1? How the whole article is linked to paper 2, chapter 2 and chapter 4? Clear? This is the idea. Public administration, if you study it like this, you can remember it very easily, and the results of it, you will have it very quickly also. Clear, people? Once again, this is my Telegram channel. Any queries that you have, you may contact me here, or anything else that you need to know, please put it up in the comment section and tell me what you think. All right. So with that, I'm winding up my session here. Once again, this is Nikhil Ram here, Public Administration faculty. Take care, people.